Thank you all for joining us today for the Benefits of a Trust presentation. We'll wait just another minute to see if any other participants join us, and then we'll get started. Very good. Well, let's get started. Thank you for joining. My name is attorney Wendy Guthro, a licensed practitioner of law, practicing currently and licensed in great Commonwealth of Massachusetts and the state of New Hampshire. You're going to hear some information today that is applicable primarily to Massachusetts and New Hampshire. If someone is joining from out of state, please be aware that this advice is not geared towards any specific attorney-client privilege, whether you're listening in or out of state, that this is for general informational purposes only, and that you should seek the advice of a licensed certified practitioner in your area or legal advice. So this is for general presentation purposes only. I have my primary office in Massachusetts, but I operate virtually. So you can always contact our office directly through our website or phone numbers that has already been sent to everyone. So let's get started and go right into the materials. Today, we are talking about the benefits of a trust. We're going to cover some of the basic differences of revocable trust versus an irrevocable trust. And then we're going to talk a little bit about how a will and trust differ, and what things you could use a trust for, and whether you really even need one, right? We don't want to just assume everyone needs a trust. And if you can kind of figure out what your situation is, take some of the information you hear today, you'll be able to easily answer that question yourself, and then we can take the next steps if needed. So I'm going to share my PowerPoint presentation. And to get us started, well, as I said, I'm Wendy Guthro, licensed in Massachusetts and New Hampshire. I do primarily estate planning, elder law, probate, and trust administration. I'm a member of the National Academy of Elder Law Attorneys, and I am admitted in multiple bars in Massachusetts and New Hampshire, and I am also a notary. What are we going to learn today? How a trust differs from a will, the difference between a revocable and an irrevocable trust, common trust uses, and is a trust right for you? And then we'll have a Q&A to address some specific queries that I often hear from clients, and then I'll open it up to the floor for questions and answers. If everyone can keep their mics muted during the presentation, and then you can put any questions in the chat that you have throughout the presentation, and I will answer them at the end, as well as we can use your hands up or just shout out if you have a question. Benefits of a trust. This is our roadmap. We're going to understand the terminology that's associated with the trust. Also, we're going to talk about a will, because there are pros and cons to using that. A trust, the different types, the difference in the process of using a trust versus not, and which is right for you. Should you use just a simple will, or is a trust right for you? And then we'll move on to questions and answers. I like to start us with the top overview of things, and that is that where does a will and a trust fall into an estate plan? And they are two of the cornerstone elements of any estate plan, which normally include these four other documents: a durable power of attorney for finances, and then three healthcare documents: a healthcare proxy, a HIPAA, and an advance directive. These each serve different functions that I'll review the first and second in detail today. And to quickly summarize that, the third item is a durable power of attorney. That is a document that you should sign while you have capacity, where you are selecting someone to serve as your, what they call an attorney in fact, a fiduciary that can make financial decisions for you when you cannot make them for yourself, or you can have them be what they call a shifting power of attorney, that they can make decisions for you while you have capacity, as well as when you don't have capacity. A healthcare proxy, who can step in and make medical decisions for you when you're unable to make them for yourself. A healthcare proxy can spring into action when needed, and when you regain capacity and you can make your own healthcare decisions again, you then regain control of making those decisions. Your HIPAA, Who can get at your protected healthcare information? We're often signing these in a doctor's office. They're specific often to the hospital or doctor's office that you're in. So this particular document, a HIPAA, you're giving permission for the named individual to be able to access your protected healthcare information. A very common use I see in and day out use is that if someone is in a hospital and you're calling in and want to get a status report on the condition of that person, you most likely have to be on their HIPAA form in order for you to be able to have access to find out how they are, to speak with the nurse's station or an on-call physician or their regular physician to figure out what's going on. So there's multiple uses for a HIPAA, but that is the second of 3 healthcare documents. The last of the 3 is an advance directive, also called a living will. And that is where you memorialize what your desires are for end-of-life care when there's no quality of life left, death is imminent, and you need to state whether you'd like to be kept alive on life support for any particular length of time, or if you would prefer for all life support equipment to be withdrawn and for you to pass away naturally. So the will, the revocable living trust we'll talk about today, the durable power of attorney for finances, and the 3 healthcare. This is a graphic depiction just so you can visually implant this, that most estate plans include these 6 documents. We're going to start with terminology to get everybody in the same port of where we are and what we're talking about. A will, most people know. It's a legal document that distributes your assets after you pass away to the new owners or the beneficiaries, right, that you have named in your will. And we bring that document to the probate court and we submit it to the probate court, and the probate court reviews it for all the necessary elements and to make sure it was a validly executed and created document. And if it is, then the distributions that you have made in that will and the people that you have selected, Massachusetts, it's called a personal representative, or in New Hampshire and other states, a executor, executrix, administrator, administratrix. So those people are appointed and a letter of authority issues that they can now be in charge of your probate estate. Now, probate court controls probate assets, and probate assets are assets that you cannot tell by looking at the asset itself who gets it next after you pass away. There are 3 parties to a will. The principal, it's normally you, the person who creates the will. The personal representative is the person that has to follow the will directions under the probate court supervision. And the third is the beneficiaries of the will, and that's the person or people or charities that are going to receive the inheritance. What is a trust? This is a little bit harder for people to wrap their head around. But if you could think of a trust as a container to hold things, as the graphic depiction down here shows. So this is your container and it's going to hold things. But the legalese of what a trust is that it's a legal entity that can hold your assets during your lifetime and distribute them after your passing without using the probate court system. So where a will we had that we were using the probate court system, a trust is not using the probate court system. And this is where a lot of your savings can take place, where you're not using the probate court system. The 3 parties to a trust. Before we had the principal, now we have a grantor, because you're going to grant your property into the trust. The second is a trustee. Before they were called the personal representative. Now they're called the trustee, and they have to follow whatever directions you put on your trust document. The third is the beneficiary. That's the same. Who is going to benefit and get to use during your lifetime and then upon your passing the assets held in this trust container. We're trying to avoid probate, so let's talk about what probate is. It's a legal process to retitle your assets into the new owner's name using the probate court system with or without a will. So if you have an individually owned bank account and you don't have a payable on death designation on it, and it's not jointly owned with anyone, and it's not in a trust, we can't tell who gets it next. So that means that you have to either take your will to the probate court where it's going to say who gets it. But if you don't have a will, the probate court in your state has their own methodology and legislation that will determine who will be the rightful heirs of your estate without a will. So under certain circumstances, we always want to have a will, especially if you don't want your property to go to your heirs at law or whatever the designation is in your particular state. Why should we avoid probate? There's privacy concerns. All documents in the probate estate and the estate administration, when we're using the probate court, become part of the public record. And this is why oftentimes on celebrity deaths, we're able to see who got Prince's estate because his will is public record. So your will can be public record as well. So some people don't want anyone to see who they decided to give their estate to. So that's one reason why we want to avoid probate. Another is the costs. On a simple probate, we have a $110 or $15 filing fee. That's for voluntary. Then we have in Massachusetts a formal and informal probate. Each one of just the filing fees are over $400. And that is before you have asked an attorney to step in and start completing any of the 8 or 12 forms that need to be completed, signed by all concerned parties, including the attorney, and if the attorney is handling it, and the beneficiaries. So it's a lot of costs involved with probate. The time that it takes, you have to leave a probate estate open in Massachusetts for at least 1 year. So if there are any creditor claims that are going to try to come and be paid through the probate estate, creditors have up to 1 year to make a claim against the estate. Mass health and Medicaid claims, right? Or mass health / Medicaid, that's what Medicaid is called in Massachusetts, that they have a right to make a claim against a probate estate to be made whole and be reimbursed or through estate recovery for any expenses that they have paid on behalf of an individual. So if there is a probate estate, Medicaid Mass Health uses the probate process to be made whole and be restored for any money they have fronted for a beneficiary of a Medicaid claim. Section number 2, wills. Let's talk about the pros and cons of a will. So the pros of a con is that it ensures your assets are distributed according to your wishes. So if you have one child maybe that you are disinheriting, he's fallen out of favor, that has chosen not to have a relationship with you, and you want to maybe not just do a general distribution to all of your heirs at law, your children or family members. You want to make sure that your assets are distributed according to your wishes by putting that in a will. Having a will minimizes family conflicts over an inheritance as well, because it's laid out in very clear language, hopefully, who you would like to receive your assets upon your passing. You can a will allows you to designate guardians for minor children. There is some tax planning that can be done in a will to help minimize estate taxes or death taxes upon your passing. And that oftentimes people have a lot of peace of mind after they create a will, memorialize what they would like in their estate plan, who should be in charge of it, and that they just have that feeling that I've at least taken care of that. So it provides some reassurances and clarity. Some of the negatives of a will is that it's public record. We spoke about that briefly. It becomes part of the public record, filed with the court, including beneficiary distributions. It's easier to challenge a will because there is a set out process in most states to challenge a will, especially if there's a disgruntled heir, we spoke about the fees and time associated with the probate process. A will does not cover all assets, such as life insurance or retirement accounts, often are not included in a will, that you have to make those designations on those individual assets. And that jointly owned property is not governed in a will, right? Because say if a husband and wife have a joint bank account and one of them passes away and the will says, give everything to my children. Well, that jointly held bank account will not be governed by your will because jointly owned property usurps a will. And then if you want to make changes to your will, it needs regular updates often to reflect family changes. And you need to use witnesses and notaries. And all of the regular formalities that you first had with executing a will have to remain in place and occur again anytime you need to make a change to your will. Having a will does not avoid probate. I cannot tell you how many people, clients, people I meet on the street say to me, well, I have a will, so I'm not going to go to probate. This is not correct. A will opens probate. So while a will is essential for your estate plan, it does not keep your estate out of the probate court. I like to talk about will substitutes because these keep assets out of your will. So whatever you have in your will as designations of who you'd like to receive certain assets, if you have any assets held in any of these manners, your will is not going to matter what it says. So if you transfer a piece of jewelry to your grandchild during your lifetime, and your will says, give that to my eldest born son, well, you transferred something during life. So it's a deemed and it will not transfer via your will. Jointly titled assets, we spoke about that already. A beneficiary designation on a life insurance policy, say, or a brokerage account. Payable on death designations on bank accounts. They're called PODs, TODs, Totten trust accounts. The P is payable on death, the T is transfer on death. And for most bank accounts, money markets, savings accounts, checking accounts, all have the flexibility at most banks to have a payable on death designation. And if you have someone designated, that asset will not pass through your will. And then a life estate deed for real estate. Some states have the availability to do that. Some other states also have the availability to name on a deed who is going to be the successor owner. Massachusetts does not have that, nor does New Hampshire. But a life estate deed is we are saying that you're giving your property, say, to your children, but you're retaining the right to live in the property for your rest of your life. That avoids probate. Not very good tax planning in that, but it does avoid probate. And I mean capital gain tax planning. And then assets held in trust, which is the basis for this presentation. Why trusts are advantageous? Because they are a will substitute. Let's talk about trusts, different types, and the benefits. Reiterating again, what is a trust? It's a container to hold things. And the words we write on this trust are going to determine what type of trust it is. A trust is a legal entity that can hold your assets during your lifetime, distribute them after your passing or during your lifetime without using the probate court system. So oftentimes when we create a trust, it's for an individual. I have my own trust, a married couple, brothers and sisters have them together, but you create this trust, right? And here you can see is a graphic depiction of that. Here's the container, and you're the grantor of the trust, meaning that you're transferring the deed to your real estate into the trust. So you're granting it. The trustee is oftentimes you, if it's a revocable living trust, as this here is a depiction of a revocable trust to avoid probate. You create the container, you're the grantor, you are the trustee, and you are the beneficiary during your lifetime. And that you retain control in this revocable trust for as long as you state you're going to retain control with the words we put on the trust. So you create the trust. You are in all three positions if it's a revocable living trust most of the time for estate planning and probate avoidance. And then we transfer the deed to your home into the trust. We transfer your personal property into the trust with an assignment of personal property, a document you sign. And then you transfer your bank account, CDs, stocks and bonds, mutual funds into the trust. And your savings bonds can be retitled into a trust as well. I would like to bring to your attention one thing that is not listed here for funding a trust, and that is retirement assets. Any IRAs, 401ks, IRA CDs, things like that. Those are held in your individual name. This trust is a separate entity and is no longer considered you owning it as an individual. So it would be a taxable event for you to cash out your IRA CD to then put it into the trust. So there's very specific guidance that your financial advisor or your attorney gives you when we talk about what we're going to do with retirement assets in your estate plan. So this is a graphic depiction of a trust, and this is the revocable where you are in all of these positions and you are retaining control of the asset. And that is this first entry here, this revocable. And this is a trust that has changeable terms. The grantor, you in most cases, you retain the control to do anything you want with the contents of this trust or the trust itself. It can be modified. It can be terminated. Right? You can change who the trustees are going to be. You can change who the beneficiaries are going to be. You can take assets and put them into the trust. You can pull assets out of the trust. So complete flexibility, almost equivalent to you owning the assets in your own name versus an irrevocable trust. And I put this in red because I want everyone to have a certain amount of beware, right? When it comes to an irrevocable trust, because it's an unalterable trust. You cannot change the terms once you have created them. And the grantor, you most of the time, you forfeit control over whatever you transfer into this irrevocable trust. And it cannot be changed. Certain trusts, such as maybe a Medicaid asset protection planning trust to start a 5-year look-back period for Medicaid, certain trusts language can be drafted into that irrevocable trust to make some minor changes. But for the most part, irrevocable trusts, once drafted, cannot be changed. So we want you to be aware before you create and fund an irrevocable trust to understand what you are forfeiting when you do fund that trust. We're going to first talk about the benefits of a revocable trust. So we talked about how a will opens up probate. Conversely, a revocable or irrevocable trust bypasses probate, which is time consuming. It maintains confidentiality of the distributions that you want to make. So all of those distributions you made in your will that now all the world can see at the registry, the registry of probate, when you have all those assets in a trust, this is not a public record. So privacy is maintained and confidentiality is maintained. It allows easy modification of the trust terms and can reduce estate taxes if you're a married couple and you're going to be doing a tax planning trust with some credit shelter trust planning that we don't need to go into today. Suffice it to say that if you have a trust and you ask for a tax planning trust as a husband and wife or partners, two spouses, that you can have some estate tax planning put into that trust. When you create the trust and you are the trustee, we put successor trustees and successor beneficiaries into your trust, so it ensures seamless asset management while you're alive, and if you become incapacitated, and then also upon passing, upon death, So you set up your trust now how you want it, and then we ask a series of questions of like, well, what if this happens? And then what if that happens? Well, what if this happens? And that's how we create the seamless asset management plan. And when you're dealing with a revocable trust, all of that can be changed. So if this year, this is how you feel, and if you have a change in circumstances, a marriage, a death, a child or beneficiary with addiction issues or mental health issues that we don't want to give money outright to them, we can easily make changes on a revocable trust. But that if you become incapacitated, we already have someone ready to step up and at least manage the trust in the event you cannot do it yourself. And that a trust facilitates a very smooth transition of assets to beneficiaries during your lifetime upon your passing. So very nice, it has smooth succession. So a revocable trust, changeable terms, you as the grantor retain control of the assets. It can be modified. It's often considered synonymous to you, the grantor, owning the asset in your individual name, but it has the added benefit that you're not going to go to probate and all of your affairs will be kept private. We're switching now to the irrevocable trust, or irrevocable is another pronunciation for it. Why do people use these? Mainly it's for asset protection. You either want to get an asset out of your estate, also for tax efficiencies. You are trying to do some asset protection planning using the Medicaid 5-year look-back rule. So we could create a Medicaid asset protection trust, transfer your assets into it. That starts a 5-year look-back period. So if you want to qualify for Medicaid welfare-based coverage of your nursing home care, or sometimes also in-home care, but you need to protect your assets 5 years in advance, you do that with an irrevocable trust. Irrevocable trusts facilitate tax advantage charitable contributions as well, and that they also ensure long-term financial support and care if you have a disabled beneficiary or maybe a beneficiary with some special needs, maybe not fully disabled, maybe they just have some learning disabilities or don't have good money management skills, that we can create an irrevocable trust that could be for their benefit. And when we create that special needs trust, or we really refer to them as supplemental needs trust, because we're very sensitive to what benefits that individual may be receiving from the government. And we are not going to use any assets from that trust to replace the government benefit, but we're going to supplement the government benefit with money from this trust. So this is not a specific supplemental needs trust presentation, but it's good to know that the irrevocable trusts that are used for supplemental needs individuals really helps them get a bucket of money that can be used for their supplemental needs, vacations, bowling, haircuts, a better apartment maybe, things like that, buying them a home, that we are allowed to do that with assets from a supplemental needs trust for an individual with special needs, but all based upon the language that would be put into and drafted into the irrevocable supplemental needs trust. So we covered the different types of trusts. We did the pros and cons, right, of trusts, and that these are general pros of trust, whether it's revocable or irrevocable. So they avoid probate. They can maintain estate privacy of distributions. We can have incapacity planning. We do have incapacity planning built into both types of trusts if you cannot be the trustee any longer. They can reduce estate and gift tax liability by the estate or an individual in some instances. They can help qualify for Medicaid to start a 5-year look-back period, and that they can provide some special needs planning for individuals with some disabilities. There's a difference in the process of each one of those types, whether it's a will or a trust, right? When you pass away. So we're going to cover that if you have a will versus a trust, what happens. So if you have a will, it's a legal document that distributes your assets after you pass away to the next owner. Now, a will only comes to fruition when you pass away. So I don't even really recommend my clients put their final wishes of where they want to be buried or cremated and things like that in a will, because oftentimes the will isn't even looked at for weeks after someone passes away. So we really want a more living, breathing document where you might go to look for that. It would be a trust or a prepayment or pre-planning of a burial contract at your local funeral services of where you would like those arrangements to be made. So we have the will, it's going to use the probate court. A trust will not use the probate court system. Here's a graphic depiction of the process. You take your probate assets and then you take your will. You bring them to the probate court, and the probate court appoints a personal representative to be in charge with the court of then corralling all your assets together, distributing them to the named beneficiaries after all the debts of your estate have been paid, and after, if Medicaid, Mass Health estate recovery is involved, after they're paid. You leave the estate open for 1 year for creditor claims, and only after those events have taken place do the beneficiaries receive any money if there's any left. So it's costly, it takes 1 year, it's a public process, and there's no asset protection planning in a will. Conversely, non-probate assets would be a trust, and then the trust document, you're in charge of it during your lifetime, but upon your passing, we have a very peaceful successor trustee that you have hand selected to oversee the distribution of paying your bills, corralling all your assets together, but most of the time you have funded your trust. You've put your deed in the trust. You've put your bank accounts in the trust. You've put your brokerage accounts into the trust. So the trustee already knows what assets they have to deal with, and they're looking at the trust document to say, who have you selected as these beneficiaries? And then a trustee can oftentimes make immediate distributions to your named beneficiaries after all of your debts have been paid and such like that. So it's immediate, it's private. The only ones that get a copy of the trust are those named in the trust, or potentially, normally all of your children or heirs at law, and that there can be some asset protection planning if you're doing the irrevocable trust. A will versus a trust. Which one is right for your estate plan? So it depends. That's a very common lawyerly answer, but things depend because every client brings a different scenario to the table that we need to kind of review and figure out, well, if it's a couple, right? If this spouse dies first, well, then what is the asset structure going to look like? Where does the money, is it a first marriage or a second marriage? Are there children from all one marriage? Or are there 2 from one marriage, 2 from the first spouse's marriage, 1 from the second spouse's marriage, and 3 joint children of the spouse 1 and 2? So these family structures, if you want to disinherit someone, right? So there's a lot of things that come into play when you sit down with an attorney and try to figure out, what should I do? Should I just do a will, or should I do a trust? So it depends on your asset type and the value of the assets, whether we have to do a tax planning plan for you or not, your family structure, who you're going to select to be the beneficiary of your estate, whether you need privacy. Some people say they don't care if their assets and beneficiaries get spewed through the probate court. But if you have a need for privacy and you want to keep things more, undercover, right? That you might want to think about a trust. But your desire for asset protection planning, whether it's for Medicaid asset protection planning, whether it is for a special needs child, right? So a disabled child, that those would be reasons that you would be discussing with your estate planning professional which plan is right for you. Special considerations, as I mentioned at the very beginning, are blended families. We often want to see something a little bit more higher level for that, oftentimes a trust. Minor children or dependents, those who bring a little bit more involved distribution schemes because we're normally not giving money outright to minor children. We're normally holding them in a trust until the youngest minor child reaches an age of majority. And then we're going to figure out, are we going to be making tiered distributions to these children, or are we going to be having their guardians get some assets together for them and distribute and pay for things that the minor children need? And then when they come to the age of majority, we might want to still consider keeping some oversight of the money to these children and distribute them maybe 1/3 at 25, 1/3 at 30, 1/3 at 35. And then, do we have any disabled beneficiaries? So these are all considerations that we take in mind when we're considering a will versus a trust. So the summary of them is that we have different players: the principal, the PR, the beneficiary, and it opens probate for a will. A trust, you're going to have a grantor, a trustee, a beneficiary, and fund trust to avoid probate with your assets. And which is right for you depends upon your assets, your family structure, and your beneficiary selection. Is a trust right for you? It is if you want to avoid probate, if you want privacy of distributions, if you want to start a 5-year Medicaid look-back period, if your estate is over the state or federal estate tax limits. In Massachusetts, that's 2 million right now. In New York, it's 5 million, I think. In New Hampshire, that's coupled with the federal rate, which is currently 13.9 million, but due to come down at the end of 2025 to $5,000 and then index to inflation. And then if we have a special needs person that we're trying to care for, to get them assets, but to not disturb public benefits. In conclusion, what should you be thinking about doing? Well, review your estate plan. Would a trust benefit your legacy or tax planning? Consider your long-term care needs. Do you have a plan? What does it look like if you had become disabled yesterday and needed a nursing home or needed a lot of care at home? Do you have your plan in place? Do you want to start a 5-year look-back period now for 5 years in the future, so that you can start protecting assets, so that you can leave a legacy to your family, and then have the government step in and pick up the $150 to $80,000 per year care in a nursing home? In Massachusetts, the rate currently is about $15,000 per month in 2025 for a nursing home, for you to pay for care in a skilled nursing facility. In the home environment, it's running more between $9,000 to $13,000 a month to bring in substantial care to keep you in your home to age in place while still needing skilled nursing level of care. So look at what you've got. Figure out whether you need legacy planning or tax planning. Consider whether you want to do any Medicaid asset protection planning or whether we want to start planning for a disabled individual. And then you can contact our office to schedule a consultation for advice tailored to your unique situation. You can email us, but you can also go to our website, guthrolaw.com, where we have a lot of videos under resources and blog posts and other articles that answer a lot of the questions that you might have. So I've started with some questions and answers that are very common that people ask me, and then I'll take your questions directly. I have a will. I do not own any real estate. All of my bank accounts are jointly titled with one of my children. Will I avoid probate? Yes, you will avoid probate. But one thing I want you to keep in mind is that When you have a jointly titled bank account with only one of your 5 children, the child who is on the jointly held bank account is the only one that has a right to all of that money. There is no legal requirement for that one child to share the money with anyone else. So you really want to be careful if you're just naming one child on the bank account, but it will avoid probate, but it may not look too pretty or really aid in good family relations if that one child decides that they are not going to share the money with the other children. Second question, I have a will. I own my home in my individual name. All of my bank accounts are jointly titled with one of my children. Will I avoid probate? No. The home will require probate to transfer it to beneficiaries or to your heirs at law, but the bank accounts will avoid probate. So you just have your own name on your home, so we can't tell by looking at that one asset who gets it next. So because of that, the house is going to probate, but the jointly titled bank accounts will not. Question number 3. I don't have a will. My spouse, who had children from a first marriage, has predeceased me. I own a house and a bank account and bank accounts in my individual name. I want our children and stepchildren to equally inherit my estate. Will that happen? So first of all, you don't have a will. So no, without a will or a trust, only your birth children will inherit your estate, because stepchildren are not included in your inheritance. Only birth children and adopted children would be part of your estate. So stepchildren are not, and that in this case, if you don't do some estate planning with a will or a trust, you might not get the outcome that you want. Question 4. I have a will that names my spouse and then my children equally as beneficiaries. One of my children is disabled and is receiving public benefits. Will an inheritance to my disabled child disturb their benefits? It depends on how the will is written. If your will states that if any distributions are going to a special needs or disabled individual, then a supplemental needs trust will be created within the will, then called a testamentary supplemental needs trust. If you don't see that language in your will, that means that the assets are going to be paid out directly to the disabled individual, and it will disturb their public benefits if those benefits are asset sensitive. Question 5. If I own a house, would I avoid probate if I created a trust and transferred the deed to my house into the trust? Yes, that's what we've been talking about with that funding picture, right? Create the trust, you transfer the deed to your home, you transfer your personal property, you transfer your bank accounts and brokerage accounts, investment accounts, all non-retirement assets, transfer your savings bonds into them. And if you do that, then you will avoid probate on any assets you put into that trust. Would my bank accounts that are in my individual name and without a payable on death beneficiary avoid probate? No. The bank accounts will not avoid probate. So they will have to go to the probate court, take your will, submit it to the court with the filing fees and all the other probate documents to get someone appointed, your personal representative, to then distribute the bank accounts according to your will if you have it, and if not a will, according to the state plan. So just as a touch point to close things up, the benefits of a trust are to avoid probate, maintain estate privacy, for incapacity planning, so that we already know who's taking care of your assets and your estate if you're alive but incapacitated, as well as upon your passing. It can reduce estate and gift taxes. You can start 5-year look-back periods for Medicaid planning, and you can create supplemental needs trust for disabled individuals. So where we started a little bit before too is review your estate plan. Do you have your cornerstone documents in place? Those 6 documents, or at least 5 of them if you're not going to need a trust? Would a will or a trust benefit your circumstances? As I said, you can go to my website at guthrolaw.com to see other information there, or you can contact our office to schedule a consultation for advice tailored to your unique situation. Or I encourage you to go to any attorney to at least put some of your basic plans in place, because I have seen the expense and the family relationships get destroyed over who's even going to be in charge of the estate, right? A lot of infighting. So if you can at least put some type of plan in place, I think that you will get such a better outcome than you could ever have imagined. If you're just going to rely on the government plan to determine who's going to get everything after you're gone, or at least to put some other people in charge. So that is the conclusion of the presentation. Well, I hope it's been helpful. Do come to our website. It has great resources, a lot of videos. Some of my previously recorded presentations are on there. If you chose to get a better, more specific assessment of your situation and whether a trust would be right for you or not, and you just kind of want to pass things by an estate planning attorney, if you contacted us, we would send you a questionnaire, an online questionnaire or paper, and you could complete it. And when it's completed, you could just touch a button. If it's online, it gets sent back to us. We review it. And then we set up, if it's for estate planning, we do a no-charge Zoom consultation or in person if needed. And we review what your family structure looks like, what your asset structure looks like, any specific situations you have, whether we have mixed and blended families, whether we have a supplemental needs person, special needs person, disabled person. And then I make a recommendation and I quote you a firm price of what it would cost to put that plan into place. And then if you're interested, we send you the engagement agreement, you sign it and return it, and then we start drafting. And normally about 4 to 5 weeks later, we're sitting down in my office and I'll get the witnesses, we'll get the notaries, we'll have you sign all of your documents. We keep your binder with us. We scan all your documents. We put them onto a jump drive and put them in a portal that you can have access to them so that you can then provide them to your advisors. If you give us the name of your financial advisor, we will communicate with them to make sure that they get at least your trust and your durable power of attorney for finances. We give you direction that we want you to put your durable power of attorney on file wherever you have retirement assets that are not held in a trust, right? As that question was asked earlier. And then we call you and let you know your binder is ready to be picked up. And then it has funding instructions in it. And we say, we've taken care of recording your deed at the Registry of Deeds and transferred it into your trust, if that's what you did. And now we've sent your documents to your financial advisor, and now you need to transfer your bank accounts by taking your trust to the bank and asking the bank to retitle your bank account into the name of your trust. And that's how you retitle assets. And then work with your financial advisor to have them change, or work with any life insurance policies to change it to maybe your surviving spouse, but if not, to your trust. And really every asset is handled differently, and the funding instructions I provide do that. So if you're interested in moving forward, if you're not already a client of mine, that's a little synopsis of the process, and that we try to kind of move this along because we know it takes a lot to get to us. So when you start the process, we try to help you move it along and get it done as quickly as possible. Well, I've enjoyed giving the presentation. I hope I've given you some value for the time that you have given to me today. If you have, you can always leave me a Google review on my website. If not, that's fine too. I'm happy to really kind of give back and help people get their estate plan going because I think it's really important, especially a document I didn't talk about at all today, which is the durable power of attorney for finances. That is a document that you do need to have in place if you don't have a trust, especially. And even if you have a trust, you still need that document to have in place to manage your retirement assets in the event you are alive but become incapacitated. So thank you very much. Have a wonderful day and happy to help you. If you need anything, you can contact at office@guthrolaw.com or go to our website at guthrolaw.com and you'll find a link there to communicate with my office. Thank you very much. Nice to see some familiar faces as well. Bye-bye. If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.